Explanation of Article 312A of the Indian Constitution. Location in the Constitution. Part 14, Services under the Union and the States. Chapter 1, Services. Purpose of Article 312A. Article 312A was inserted by the 28th Constitutional Amendment Act, 1972. It grants Parliament the power to change or revoke the service conditions, including salary, leave, pension, and disciplinary rights, of certain officers who were originally appointed to the civil services of the British Crown in India before the Constitution came into effect. It also removes judicial review over certain disputes related to their service conditions. Key provisions of Article 312A. Clause 1. Parliament's power to change service conditions. Parliament can make laws that alter or revoke the service conditions of officers who were appointed before 1950 and are still in service as of 1972. Parliament can modify or remove their rights related to salary, leave, pension, and disciplinary matters. Officers who were appointed before 1950 but retired before 1972. Parliament can modify or revoke their pension conditions. Exception for certain high-ranking officials. Parliament cannot change the service conditions after their appointment of Supreme Court and High Court judges. Controller and Auditor General of India, CAG. Chairman or members of Union and State Public Service Commissions. Chief Election Commissioner. These officials are protected from unfavorable service condition changes after their appointment. Clause 2. State legislatures' power to regulate service conditions. This clause states that state legislatures or other authorities can still regulate the service conditions of such officers unless Parliament explicitly overrides them through a law. Clause 3. No judicial review over certain disputes. The Supreme Court and other courts have no jurisdiction over disputes related to covenants, agreements, or letters given to such officers at the time of their appointment. Disputes related to Article 314, which was repealed by the 28th Amendment. Article 314, now removed, had provided protection to officers from changes in service conditions. Clause 4. Article 312A overrides Article 314. Effect: any rights given under Article 314, which was repealed, or any other constitutional provision will not limit Parliament's powers under Article 312A. Analysis of Article 312A. Why was Article 312A introduced? Abolition of special privileges of British-era officers. Before independence, many officers were appointed under British rule and had special protections regarding service conditions. Article 314, before its repeal, protected them from any unfavorable changes. To remove these protections, Article 312 was introduced through the 28th Amendment in 1972. Equal treatment of officers. Indian officers who joined after independence were not given such privileges, so the government wanted to remove inequalities in service conditions. To remove judicial challenges, the government wanted full control over modifying service conditions without courts interfering in disputes related to old agreements. Impact of Article 312A. Empowers Parliament to change the service conditions of British-era officers. Ensures uniformity in service rules for all officers. Prevents courts from interfering in old service disputes. Protects certain high-ranking officials from unfair changes in service conditions. Conclusion. Article 312A allows Parliament to change or revoke the service conditions of British-appointed officers who continued working in India after independence. It was introduced by the 28th Amendment, 1972, to remove special privileges enjoyed by such officers under Article 314, now repealed. It also removes judicial review over disputes related to their service agreements. However, judges, CAG, election commissioners, and Public Service Commission members are protected from any unfavorable service changes after their appointment. The Constitution of India. Part 14. Services under the Union and the States. Chapter 1. Services. Article 312A. Power of Parliament to vary or revoke conditions of service of officers of certain services. 1. Parliament may by law a. Vary or revoke, whether prospectively or retrospectively, the conditions of services as respects remuneration, leave and pension and the rights as respects disciplinary matters of persons who, having been appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India before the commencement of this Constitution, continue on and after the commencement of the Constitution, 28th Amendment, Act, 1972, to serve under the Government of India or of a state in any service or post. B. Vary or revoke, whether prospectively or retrospectively, the conditions of service as respects pension of persons who, having been appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India before the commencement of this Constitution, retired or otherwise ceased to be in service at any time before the commencement of the Constitution, 28th Amendment, Act, 1972. Provided that in the case of any such person who is holding or has held the office of the Chief Justice or other Judge of the Supreme Court or a High Court, the Controller and Auditor General of India, the Chairman or other member of the Union or a State Public Service Commission or the Chief Election Commissioner, nothing in subclause A or subclause B shall be construed as empowering Parliament to vary or revoke, after his appointment to such post, the conditions of his service to his disadvantage except in so far as such conditions of service are applicable to him by reason of his being a person appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India. 2. Except to the extent provided for by Parliament by law under this article, nothing in this article shall affect the power of any legislature or other authority under any other provision of this Constitution to regulate the conditions of service of persons referred to in Clause 1. 3. Neither the Supreme Court nor any other court shall have jurisdiction in a. Any dispute arising out of any provision of, or any endorsement on, any covenant, agreement or other similar instrument which was entered into or executed by any person referred to in Clause 1, or arising out of any letter issued to such person, in relation to his appointment to any civil service of the Crown in India or his continuance in service under the government of the Dominion of India or a province thereof. B. Any dispute in respect of any right, liability or obligation under Article 314 as originally enacted. 4. The provisions of this article shall have effect notwithstanding anything in Article 314 as originally enacted or in any other provision of this Constitution.